there is a different way to approach the work that you do, and that you are able to support communities and support the people that you work with to also know, use, and shape the law for themselves. I'm now about to hand over to Worship Roseline and Nsenge for our first session of the day. And let me give you a brief overview of our program. And so Her Worship Nsenge will be leading the first session that will run for about an hour and a half. And we will end the session at 10:30 and have a short break. And then we will start the second session at about 10:40 that will be led by Dr. Annette Mbogoh. And this session will be focused on community legal volunteerism. So the second session will end at 12 p.m. And so today we are trying something new and something different with our CLE trainings that we've not done in the past. And those who've been with us know that we usually have 5 hours of training, and that will include some group work and group discussions. But today we are doing something different. And so at the end of the session that will be led by Dr. Mbogoh, that will end at noon, we will be providing a take-home assignment, and that everyone who is in this training will have 3 hours to complete. And so there will be the 3 hours up to 3 p.m. for those participating to submit the written assignment back to us, but will of course be based on what we have learned and what we have talked about in this training. And that will be the final components for ensuring earning of CLE points. And so those who do return back and completed assignments will be eligible for earning CLE points at the end of the training. And please take note of the deadline that will be 3 p.m. today. And so at this point, allow me to share a very brief profile of Her Worship Roseline Nsenge. And so very interestingly, Her Worship started her career, the very first work, not even work, first as a volunteer, as a student, and was at FIDAUg. She joined FIDAUg at the time when we were a much smaller organization with much fewer resources. And she was here at FIDAUg for 5 years, and where she poured her heart and soul into the work that we do. And she was part of the process of building the organization from where she found it to where it was when she left 5 years later. And from there, Her Worship Nsenge joined the bench. She went to the judiciary as a very young lawyer, and she served as first as a magistrate grade 1, and now she is the chief magistrate of the Federal Chief Magistrates Courts. And I'd also like to note that she is the elected secretary of the Uganda chapter of the International Association of Women Judges. So that was a very, very brief profile. And Her Worship, we are very honored to have you today. Thank you for being a very active member at FIDAUg, even all these years after leaving us in your capacity as a staff member, and we look forward to what we're going to learn from you today about people-centered justice and legal empowerment approaches and legal aid supervision.
Okay, thank you so much, Annette. Good morning, everyone online. It's always a pleasure to be back here at FIDAUg, to be part of the Training Academy. FIDAUg is my home. It is a place that I feel all the female lawyers around, they should start. So before we start off the training, in a very special way, I want to allow me to thank the FIDAUg administration for giving me the opportunity once again to invite me back home to FIDAUg Uganda to be part of the Training Academy. And also in a very special way, I wish to thank the advocates, the lawyers, the gallant lawyers working with FIDAUg Uganda. You work with a lot of passion, you work with a lot of commitment, and I think working with FIDAUg Uganda is not work, it is actually a service. So well done, and we really, really appreciate for serving the community. So let us get down into business, and we do FIDAUg the training on legal empowerment approaches to legal aid service provision. Start. So I always like where I have started the introduction. For far too long and in too many jurisdictions, we have approached the justice system, strengthening from the perspective of institutions. We have asked what to do as judges, lawyers, prosecutors, and bar associations, what is needed to do their jobs better, without fully understanding the needs of the people. Those institutions and actors are meant to serve their claims. So basically, what this means is that at the end of the day, all the meetings, all the conferences, all the trainings are about us. How can we deliver justice better? How can we improve our facilitation better? How can we improve our resources better? But at the end of the day, how about the people, the end receivers of the justice system? So that is what we are going to talk about today. Are the people who are supposed to receive justice happy? Are they happy with the way we are doing things, or we need to change our strategy? So let's go. So the justice system, therefore, should be people-centered and focused on the humanity of the people themselves. This was said by the World Justice Project Executive Director Elizabeth Anderson in her address to the American Bar Association about putting people first. People-centered justice at home and abroad. So I looked at the law applicable in legal empowerment. I looked at Article 126 of the Constitution of the Republic of Uganda, 1995, as amended. Judicial power is derived from the people and shall be exercised by the courts established under the Constitution in the name of the people and in conformity with the law and with the values, norms, and aspirations of the people. So again, we're back to the topic, legal empowerment. So we are looking at justice in conformity with the law. Are we working within the law, or we are working outside the law? And if we are working within the law, within the constraints of the law, and is it within the values of the Ugandan people? Are those the values that we have? Are those the norms, and those are they the aspirations of the people of Uganda? So I'll relate that to the legal empowerment that we are supposed to look at. So we shall define what is legal empowerment. It is the process. It actually has very many definitions, but I'll break it down as we move on. It is the process through which the poor become protected and are enabled to use the law to advance their rights and their interests in relation to the state and the market. So how are we protecting the poor? How are we protecting the vulnerable people? Are they empowered enough? Can this person that you're representing, the vulnerable person, can that person stand in a court of law by themselves without your presence? Or you have made them more, you will look at these people more of like they are poor, they are vulnerable. So all the time we are looking at them as victims. So legal empowerment, here we are saying, can we empower them so that they use the law more and they don't look at themselves as victims? Can they be empowered enough to fight for their own rights? So legal empowerment, it is a rule of law approach that relies on the perspectives, needs, strengths, and expectations of the justice user to improve the quality of justice and reduce barriers to service delivery. So here, when we're talking about legal aid service provision, and actually even widely even to the lawyers who are in private practice, we have these vulnerable people, we have these clients before us, but we are coming up with all sorts of technicalities. We are putting up so many barriers, the expenses are too high, and even the technicalities, the documentation is too much. Why don't we find ways in which we can look at vulnerable people, poor people, and serve them better and we reduce the barriers to service delivery? So I also looked at, it focuses on understanding people's justice needs and transforming justice institutions and other services to meet those needs rather than enforcing institutions to which people do not turn to. So you have this client of yours, perhaps maybe you are FIDAUg advocate, or you are in the legal aid provision, or you are in private practice, and you have this client before you. And instead of thinking out of the box, the end result of justice, all you're thinking about is, okay, so I'm going to litigate this matter. How fast can I go to court? What kind of documentation do we need? But have you looked outside the box to see how this person can get justice, even without the technicalities, even without enforcing the institutions? That is our topic today. Let's move forward. So it also focuses on understanding, okay, people's needs and to make okay. It is about strengthening the capacity of all people. I like this very, very much. It is about strengthening the capacity of all people to exercise their rights, either as individuals or as members of a community. You have the capacity as an advocate. You're armed with the law. But now you have these people around you. You're not always going to find time to meet them. But when someone comes up with a matter, they need they're not going to meet you just once. You need to have several meetings. But does this litigant have the capacity to meet you often? And where are they going to meet you? Do they have the transport to actually meet you? So why don't you build their capacity to exercise their own right? Why would you let somebody travel a long distance just because they are looking for you? And not only that they are looking for you, but they can actually do without you. You can work remotely if you build their capacity in one way or another. So it's also about grassroots justice, about ensuring that law is not confined to books or courtrooms, but rather is available and meaningful to ordinary people. So legal empowerment puts the power of the law into people's hands. So it is not about court. And from my experience with FIDAUg Uganda is that so many matters are handled in the legal aid clinic. These matters are never taken before the courts of law. So meaning that the FIDA lawyers are empowered enough and they are empowering their clients actually to conclude matters that would be so confined to books or courts of laws, and we see these matters in courts of law for ages. Somebody has come with a child who does not have school fees, but the matter is taking more than a year before a court of law. Why don't we empower communities? Why don't we empower ourselves and and individual litigants so that some of these matters actually we don't go to court. They don't have to go to court. Let us put the law into people's hands. And then even when people go to court, you don't have to go there with them. Empower them. For instance, if you have your one advocate and you have more than 5 files in a day, and perhaps maybe the judicial officers have allocated to you almost the same time, empower the person, empower the individuals, empower the communities, so that somebody can go to a court of law and one, perhaps maybe even because of the empowerment that they have received from you. So legal empowerment also allows communities facing injustice to fight back. So like FIDAUg Uganda does community outreaches to empower people. You go out to the communities and you're training people. This you can do even when the lawyers are not there. This you can. So even like, for instance, at the lower level for the local council courts. Local council courts, we have secretary for children affairs. Even the chairperson themselves, you empower these communities like FIDAUg Uganda does, so that they are not so much, every time the reliance, so that they can become self-reliant and everything is not about you as an advocate. Because the law does not resolve around you as an advocate. No, it doesn't. But you use it to empower other people in the best way possible. So it is an agenda. This agenda aims to incorporate the best practices of informed systems into the formal legal system and to reform existing formal institutions to make them open, accessible, and legitimate. So basically what I'm trying to say here is that let us liberalize the formal system. Why would a custody matter? Why wouldn't you empower a litigant like FIDAUg Uganda does, especially the lawyers who sit in the legal aid clinic and they're handling mediations and they're trying to put, the aim result is reconciliation, putting people together as advocates and people in the legal aid practice. I think what we should avoid to do is to escalate matters. Don't build a matter which is not supposed to be escalated. Other than to resolve it, you try to make it worse than the situation looks like. No, let us not descend so much into the arena. Let us detach ourselves from the matters. We empower people, and at the end of the day, it will be people-centered and everybody will enjoy justice. So I'll go back to Article 126(1). Of the Constitution, which provides that judicial power, I started with it, is derived from the people and shall be exercised by the courts. established under this constitution. In the name of the people, you can see it's coming up again, in the name of the people. So not in the name of the technicalities or the legal barriers that will come up in the courts. We come up with all sorts of, complicities. To make matters very complicated, escalating them and making them worse than it can be. And the constant in power as a legal aid provider and as an advocate, please maintain the values, the norms and aspirations of the people. It should be within your interest. Don't escalate matters. Don't make communities live in isolation. Let communities not live, because I wouldn't want us to promote anarchy within our So why the legal empowerment approach? Why are we changing? Because even the judiciary is moving away. We are moving away from this litigious kind of thing, and now I think it is about a DRA, alternative dispute resolution. So the most serious categories of legal problems faced by Ugandans in the administration of justice are land matters, family problems, crime, and domestic violence, amongst others. According, this was a Hill survey report. It is actually very updated, 2024. It is a 2024 report. Therefore, there is a need for justice actors to find ways of addressing the challenges so that people's justice needs in those specific areas are addressed. According to the said survey report, the people of Uganda prefer to use informal ways or mechanisms in resolving disputes. A big part of the population still uses customary forms of settling disputes as reconciliation, restitutions, and negotiations. So I would want to also make a few comments in regard to this report. Why is it that most of the population in Uganda prefers to use informal ways or mechanisms in resolving disputes? One, there are no technicalities, and it is cheap and it is fast. Honestly, if somebody has a domestic problem, a domestic issue, why would it take a year or two to be resolved? Why wouldn't that be resolved in 2 years? If I can walk into FIDAUg Uganda and I meet maybe the lawyers in the legal aid clinic, and they try to take us through, and they empower us if you have a problem, and at the end of the day, they are promoting reconciliation, restitution. That's the end of the problem. Other than waiting, one, I have to instruct counsel. So I have instructed counsel, which is good, but counsel immediately is not telling me about the other options that I may have to resolve the issue that I have before him. All he's saying is that, no, we have to go to court. This is a matter that has to be resolved in court, and which is okay. But now we go to court, one, the expenses, because they are filing fees in courts. They're filing fees, and oftentimes, most of the Ugandan people who seek legal redress, these are people who cannot afford. But now we are pushing them to afford the formal justice system. So the matter is filed before court, and guess what? The matter is given a date. Perhaps maybe if it is a short date, then they are going to give that matter perhaps maybe a month from the day the matter has been filed in court, because courts are really, they have so many matters before them. It is way beyond their ability. So the judicial officer perhaps is also gender sensitive and gives a date perhaps after 1 month. But this is a matter that needs to be resolved there and then. So what happens in that 1 month period? So that's why I'm saying that let us push for the agenda of legal empowerment. Let us empower individuals, let us empower communities going forward. Yes. So people face many challenges in their quest to seek justice. Hence, many have given up on institutions set to administer justice. Again, this goes back to what I was saying earlier. So the challenges, as in the process is too prolonged. When someone has an issue, they want it resolved, at least in the quickest period possible. But then with the heinous justice system in Uganda, it takes quite some time. And you all can agree with me that you cannot have a matter and get it resolved in 1 day or 1 week. And that's why the courts are moving away from the heinous litigious systems to alternative dispute resolutions. So why legal empowerment again, the delayed and expensive justice, the high levels of bureaucracy in justice institutions, appearing in court without legal representation, with the notion that it is expensive to instruct one, and ignorance of the law and institutions that enforce it. When the litigants, the clients, have problems and they give the advocates instructions or even the legal aid providers, I think the least thing somebody would expect is for somebody to immediately put in costs, which is inevitable because they're not going to do the work unless if you're going to organizations like FIDAUg Uganda where the services are pro bono. But even when the services are pro bono in FIDAUg still, even when they go to courts, they have to pay the filing fees. Now the question is, can FIDAUg afford to pay the filing fees? And if it can afford to pay the filing fees, for how many people can it afford to? So, and it doesn't only stop at the filing fees, but then the matter is not going to be heard in 1 day. The matter is going to be heard in a couple of weeks or in a couple of months or even a year. So meaning that at every time of hearing the matter, there should be an advocate on representing the litigant together with the litigant. So the litigant has to travel a distance from wherever they come from to come meet the advocate, and then they have to travel together or they have to meet at the court and to have the matter heard. And then on that day, the matter is not going to be concluded. The matter is going to perhaps maybe to kick off and it will be partially heard. Now, this kind of delayed and expensive justice, it really puts off people, the bureaucracy in the justice system. Why wouldn't someone walk in, perhaps maybe walks in today? That is, if we're to talk about people-centered justice, if someone has an issue, they have taken off time and they've done everything within their power to actually instruct advocates. So they go to court, and what happens? The matter cannot kick off that day, or if it kicks off, then it is partially heard. So people this really pisses them off, and that's why you find that in most courts, actually, there are matters which are just dismissed not because people are not interested. These matters are dismissed because people are, they're just put off with the entire bureaucracy in the justice system because of the delays and the expensive justice, and they leave it to us, the custodians of the law. And what we do as custodians of the law, we dismiss. But what happens to the problem of the problem that the person had? Has it been resolved? No, the problem has not been resolved in any way. So they go back to their homes, and perhaps some of them take the law into their hands, not because they wanted to take that route, but I think because of the bureaucracies, because of the disappointment in the justice institutions. So we're saying, can we change? Can we empower people? Can we make it more people-centered other than just all the time pushing for how institutions can work better? This can do this. Let us empower people. So legal empowerment approach. It enables the end users of the justice system to fully participate in the justice system, which makes it a more satisfactory approach. Therefore, legal empowerment, it focuses on people's everyday justice problems and improving the quality of their justice journeys, which means empowering people to understand and use the law, providing justice services that are people-centered and enabling fair outcomes and remedies. Because again, okay, you have represented a client and you have got remedies, but do those remedies work for that person? Okay, if you have helped the client and you had the instructions and you went to court, we as judicial officers, you have come up with remedies and you've issued orders, but are those orders people-centered? At the end of the day, is it going to help the litigant in any way? Or you're already making an already worse situation, you're worsening it by escalating matters. Of course, you've got a remedy, but is it a good remedy? When you look at the outcome, is it a good outcome? These are the questions that we should be asking ourselves. That even as we try to go through the justice system, are we looking at ourselves? Whom are we serving? Are we serving ourselves? Are we serving the people who supervise us? Or we are serving the people, the people at the end result of the justice system that we believe in? Let us serve communities. So it is aimed at expanding protection and opportunity for all. Protecting poor people from injustices such as wrongful evictions, exploration, extortion, and exploitation. Because now, if the communities are empowered, especially when it comes to land matters, resolving around widows, no one is going to wake up one day and you go to land belonging to a widow, an empowered widow, and you evict her. Of course, she's going to question the status quo because she's empowered. She will not sit back and cry. You're not going to evict her and say, no, now this has happened. You don't have land here. No, she will not just get, you will not get away with it. So when we empower people, they will be in position to fight for themselves. They will be in position to put up a good fight for themselves. And at the end of the day, it is not even just enough for someone to exploit maybe a widow or somebody taking up someone's land. But if someone can put up a fight and at least, maybe call FIDAUg or look out for a lawyer, I think that is good empowerment. It is good empowerment enough for someone to know that, oh, there is land that I can do something about it. Someone will not take advantage of me. Let me try to maybe report or something other than to just cry and somebody's evicted and they have nowhere to go, they're on the streets and they think that there is no remedy. And then they are evicted. So it also ensures that people have equal opportunities to access local, national, and international markets. So because when you are empowered, when communities are empowered, they will know that you can't take advantage of people. If there are opportunities in their communities, they will take up the opportunities and they will be in position to access whatever that they can. So legal empowerment initiatives, they have the potential to benefit women through, for example, affirming women's inheritance, labor rights, reducing gender violence, and a host of other goals. When women are empowered and when legal aid service providers and practicing lawyers in private practice, when you empower the communities, when you empower individuals, they are able to fight for themselves. They are able to use the law, at least up to a certain extent. There will not be anybody pleading ignorance. They will have somewhere to start. Unlike somebody who is not empowered. Someone who is not empowered will not think of any other remedy other than to use the fists, other than to use their physical energy, which is uncalled for. There are remedies, and if we empower people, I think we shall resolve so many problems in the communities, and even the cases that go before the courts of law will reduce. It has the potential to assist marginalized and vulnerable groups in overcoming obstacles such as affordability of user costs, lack of legal representation, alienation due to technicalities, and ignorance. I think I already discussed this. So through legal aid strategies, legal empowerment can enable the disadvantaged to increase their effective participation in family, community, and government decision making. When communities are empowered, when women are empowered, even when they are positions, decision-making positions in their communities, women who are empowered will take up these positions because of the empowerment that they receive. And even when it comes to participation in the community affairs and in family affairs, when we empower people, when we empower women specifically, I think we shall have better families, we shall have better, people will live in harmony, even communities, because of bigger empowerment. People will know what to do, people will know where to go, and they will seek the relevant redress where possible. So I'm also looking at adopting an approach. So I'm looking at practical steps and approaches that can be adopted by legal practitioners to ensure that the services they deliver go beyond aid. So you're providing legal aid, but is it practical? Or someone says that, no, my children are not going to school, and I'm here, and the father of the children is maybe he lays bricks. Perhaps maybe he also can't afford. So for you as a legal aid service provider, what are the practical steps? What are the approaches? What is the advice that you are giving this client? Are you still insisting on going to court? We have to carry it. But the person has told you that even the father of the children does not have capacity. So what do you do as a legal aid service provider? Do you push and you bring the matter before court? And at the end of the day, court is issuing orders that the defendant, you're hereby, the respondent, you're hereby ordered to pay school fees for your children, because the wife, maybe her wishes are that she wants to take the child to a school where they're paying 1 million shillings, but the respondent cannot even afford 150,000. And you actually have evidence as a legal service provider to be.
Apologies, and apologies, ladies, and to every ladies along today. And sorry about that, we lost our prediction here at allocation that we this for a little while. But we are back on, so we should please continue your things off.
Okay, so I was making a point about practical steps and approaches that can be adopted by legal practitioners to ensure that the services they deliver go beyond aid. And I was discussing adopting an approach that assumes prime and wisdom
through legal literacy. Yes, you are empowering the litigants, you've empowered them, you've empowered your clients, but I'm saying don't overraise someone's expectations. Try to be very realistic at the end of the day. And I was giving an example that, for instance, if a lady has been empowered enough and she knows that, okay, as a remedy, if someone is not providing for the children, I'm going to report my matter to FIDAUg Uganda. And so this lady is empowered enough. But again, as FIDAUg Uganda advocates and lawyers, we should be very, very realistic, even with the private advocates, that if this person walks into our chambers, our offices, let us be realistic with them and honest with them and not make them believe that FIDAUg Uganda or the private lawyer that you are, the good advocate that you are going to perform miracles. For instance, if the father of the child is earning 150,000 and you have proof, you have actually done due diligence to go to the place where they work and they have shown you a payslip of 150,000. And the lady the wife is of the view that I cannot take my child to this school, but she's not working, she is a housewife, and she doesn't earn anything. There are that kind of scenarios. And she says, I want to take my child to this school and they pay 1 million shillings per term. So as service providers, let us offer services that are people-centered in a way that let us be realistic, let us be honest with the people that we serve. So when you get angry as a FIDAUg advocate or as a private advocate who is armed with all the law, and you say, no, this man is just refusing, but you have a payslip of 150. Let us take this matter to court. So this matter ends up in court. So when this matter ends up in court for maintenance and custody and her worship, here you are, you're issuing orders. And thank you so much for the justice, the delivery of justice. It's been quick justice. But let us look at the end results. You're issuing orders. It has, first of all, started with the legal aid provider or the private advocate, the advocate in private practice. So we are looking for school fees for this child, perhaps also maintenance. And we have a payslip of 150,000 from the person supposed to pay. And the house and the wife is a housewife. She doesn't have any source of income. So here, you know, it is like we come from the legal service providers, the private practitioners, and on we are taking it to court. So in court, her worship is very, very gender sensitive. So when you ask all sorts of questions, you're not paying school fees for your children, and luckily we get orders. And what are the orders reading? The orders are reading that you are hereby directed to pay school fees for your children of 1 million shillings. Okay, this is justice. But is this good justice? Is it people-centered? It isn't. It isn't, because at the end of the day, we are not being realistic. We have raised someone's expectations and we are not living within the realms of justice. So legal issues should be seen in a perspective of flexibility and not fixed. Let us be flexible. Let us live according to what, let us look at each matter as it comes. So let us not be fixed. What does the law say? The law says you should pay school fees for your child. You're supposed to pay 1 million shillings. And you know, that is it. You're not going to answer anything. That is it, and I'm issuing orders. No, let us be very, very flexible and let us be realistic. The law does not live in the museum. The law lives within human beings. Let us be extremely realistic. So there should always be an emphasis on the importance of a normative environment and context. Context in the, let us look at each matter as it comes on our table. Because if somebody maybe is a corporate and is intentionally refusing to pay school fees for his children and he says, all I can afford is 50,000, that is the context. That is the context I mean. And let us also give the law a human face. Let us say they are they and we are us. The moment we put they, the other side, and us, you know, for us, we are land people, so we want to do things in a certain way. Let us try to put ourselves in the shoes of the people that we serve. What if it were me? Would I wish to be treated this way? Okay, if I was seeking for justice for A and B, would this be the best remedy? Somebody is saying that, you know what, I'm having issues with my spouse at home, and the only remedy that you are availing that person as a very learned advocate, move out tomorrow. Move out tomorrow, but have you also provided other avenues? Where are the alternatives? Where is this person going to go? It is not enough for you to say, move out. So she moves out and she goes on the street. Let us be flexible and let us be realistic. For instance, for example, there are matters where both parties have lost interest in a matter. People are before you as an advocate and people have lost interest in the matter. Why are you complicating the matter and saying, you know, because I see it so much in court? No. Imagine both parties are in court and they are not interested in proceeding, they prefer reconciliation, and somebody the other side, a justice's jealous person says, no, we need documentation, you need to first go home, come back with this kind of documentation to show that actually there is proof that you're no longer interested. But why are people, why are we making it very, very expensive for people? Two people are in court, why wouldn't you put an enabling environment, even if it is any kind of documentation? That documentation can still be done there and then for the court of law, other than making people move, making it expensive, and then the debt you're giving them, then you're not going to be there. And then when they come, they need to come with an advocate. And then the advocate also needs transport for the day. Let us try to deliver justice that is people-centered. So relatedly, in matters where parties want to settle out of court, why push for litigation? If a matter can be handled in the legal aid clinic here at FIDAUg, Uganda, someone is not fair. Of course, the law, that's why I'm saying that we have to do everything within the confines of the law. So the person, you have someone, maybe the respondents here at FIDAUg, we did, and I know they still do because I worked with FIDAUg for 5 years. I know exactly the entire process and I've done it before. Someone in the other party, that, you know, come and tell us, why aren't you providing for your children? Person comes and says, actually, we had a disagreement home, but I'm willing to do A, B, C, D. So we'll draft memorandums of understanding, and they would sign, and we would sign, and our cash office was always very busy because litigants kept on depositing money for their children. And so that's why I'm asking that if such matters can be handled and settled properly out of court, we shouldn't push for litigation. Because again, when matters are settled out of court, there is at least you leave room for reconciliation. Someone will not be so angry with the other parties that you don't took me to court. No, because the people handling perhaps maybe a mediation at FIDAUg Uganda, or even the private practitioners, they are very professional people, and I know and I'm very sure that they do it with a lot of empathy. So at the end of the day, they are pushing for reconciliation, they are pushing for communities to live together, you know. So litigation, where there is no need, let us not push for litigation. So it is not your case. So if you're not actually, I was actually arguing that let us not be very, very passionate about pushing matters for litigation where there are available remedies. We can empower people to resolve their own matters, because we as advocates, we should not attach ourselves to the cases that we handle. We are not the litigants. We should detach ourselves from the case. And that is where it begins from. Detach yourself from the case and give objective advice. Give objective remedies. Empower somebody to a point that you know, okay, this is a matter I know very well, it can be resolved in just even a day if I empower this person. So let us not descend so much into the arena. Let us help the litigants that we serve, the people that we serve. We should empower them to become self-reliant. So stretching the legal, okay, I have like maybe 15 minutes, then 15, okay. So stretching the legal imagination, but also working within strict constraints of the law. Again, let us not do illegal things. Yeah, let us not do illegal things in a way that I think I once handled a matter where I think it was an advocate who was trying to send so much into the arena to a point of actually proposing to court that, Your Worship, if these children cannot be handled by their mother to be taken to school, I am available. In what pocket you are available to take the children to school, the children of a litigant. I think this is descending so much into the arena. And you are not working within the constraints of the law. Let us do things that are within the law. What does the law provide? But even as we are working within the constraints of the law, we can give it a broader interpretation. But even when we try to give it a broader interpretation, let it be within the constraints of the law. Don't do illegal things because nobody's above the law. When you do illegal things, then the law is going to catch up with you. So it is always important to balance the reality about life, that after all, we are all human beings. So can legal aid service providers and even practicing lawyers become more innovative in a manner in which they can provide legal aid services? Is it possible to become more innovative? Let us not be stagnant. Let us not work like we are working in a vacuum and you're like, you know what? When a client comes, I'm going to listen to the case. Then after the case, then I'm going to start drafting documents. Let us be more innovative. When you think about other people, put yourselves in that person's shoes, the one whose remedies you're seeking. Is the remedy that you are advising for them to get, would you be comfortable with this if someone advises you or proposes the same to you? I think these are some of the questions we should be asking ourselves. How can we be more innovative? How can we work to a point that when we're trying to help litigants, when people come before us, vulnerable people, how can they walk out of our chambers, of our offices, feeling that, okay, I am a lot far better than how I came? The moment you cannot, you are legal aid service provider, or you are private owner, and you cannot answer that question, then just know that you have so much to do. You have to change your strategy. You have to think about people first. Think about people that you serve. And you also have to think out of the box. I also looked at adopting an African mode of settling disputes. That is alternative justice systems and the traditional dispute resolution mechanisms. I think many of us have heard about this. Like, for instance, the judiciary is now pushing for ADR and alternative justice systems. So trying to adopt these, and these have been actually done so many times with organizations such as FIDAUg, because they are too much into settling disputes and promoting reconciliation. So this can be done by bringing the parties together and acknowledging that they are all going to live together in the same community afterwards. Okay. So what I was trying to say here is that, we have to acknowledge that when people come to our offices or chambers for help and they have matters before them, I think the question that we should have at the bottom of our minds is that this person is going to go back to the same community and you're not actually offering any kind of protection, you're just giving remedies. So what I'm trying to put forward is that now, with that at the bottom of your mind, don't escalate matters. If somebody is going to go back and live in the same community with the same people with whom she or he had problems, why don't you come up with better remedies to restore dignity and heal the social rupture, other than forms of penalties calculated to ensure continuing antagonism? What I mean here is that other than to escalate matters and make an already bad situation, you make it worse. Why don't you look at the community where this person is going to live? If the person is going to live with these people, so how can they live better with this community? Of course, the other people are not happy that this person has reported and sought for remedies outside their community. But how can we reconcile people to a point that the remedies that we are veiling can actually work even when somebody goes back to live within the communities? So to take an example of cases such as criminal trespass involving neighbors, these are land matters. It is a land boundary. A land boundary where, it is a neighbor and these neighbors are going to live together permanently. So as a legal practitioner and a legal aid service providers, what happens to such communities, to such neighbors? Are you going to escalate matters to a point that they should compensate you now this amount of money? Why don't you push for reconciliation? And this calls for the Ubuntu notion. I am because we are. My thoughts go to the relationship between reason and passion, and then to the concept of human dignity and proportionality. So being an innovative practitioner, there is need to find expression in innovative ways. For example, personally, I have trained local council executive members in the various jurisdictions where I have been stationed. So when you empower local council leaders, you have empowered these, I think they're about, are they 12 on the health committee? You empower 12 people, but at the end of the day, you have empowered the entire community. The community may have over 5,000 people. So you as one legal aid provider or private practitioner, you may not have time to meet thousands of people. There is no time for that. But just empowering, take off time and empower the local councils. You'll have empowered thousands of people within the community. This has various advantages such as reduction of crime, people in the community being knowledgeable of their rights, zero tolerance to domestic violence and sexual offenses, and exposure of where to find immediate remedies. So for us as judicial officers, we try as much as possible, because at the end of the day, when the matters fail with the legal aid service providers to do the settlements, the matters end in court. So when we are in court, we should try as much as possible, perhaps maybe to use the court halls as a classroom. If you can, you empower people. Someone may be in court and actually realizes that their matter should have never at any one time have ended up in court, just because you have taken off some time to empower them. Just you take off about 5 minutes, you empower people, tell them about their rights, tell them about the law. Of course, not to give them the entire law lectures, but their basics. You empower them. So you see people actually walking out like, oh, I'm in the wrong place. I ought to have concluded this, maybe perhaps with FIDAUg Uganda. Already FIDAUg Uganda had played their part, and I'm here. I don't know, I thought that court would maybe perform miracles, but actually what they did for me the other side was better. Also, as judicial officers, maybe courts should give befitting verdicts, such as compensations and raising awareness of laws and judicial processes, so that people can be motivated to report their cases with confidence. Because again, if the verdicts which come from us as judicial officers are very hard to actually even understand. Okay, it is a verdict. You have ordered for compensation. You have made orders that somebody who earns 150,000 per month should pay 1 million shillings for school fees for a child. And you have the pay slip. Is that a befitting verdict? These are the questions we should be asking ourselves. Is this really people-centered? At the end of the day, the end receiver of this verdict has he benefited, or we are going to have more people thrown in prison as civil debtors? So we have to be extremely cautious and careful, even as together as custodians of the law and also court users. So simplified and timely judgment, because when the legal aid service providers come to courts of law seeking for redress for the people in the communities, the people that we serve, and also the private legal practitioners, some of the judgments are too huge and the language cannot be easily understood. They are not persuasive. We are saying so much. So I would advocate that if we could just keep it straight to the point, be simple and clear, so that at the end of the day, the legal aid service provider or the private advocate does not labor so much to interpret what the judgment is about. The document should actually speak for itself. So I've already spoken about alternative justice systems and the traditional dispute resolution mechanisms such as mediation. Mediation is very, very important because not only can mediation reduce the expenses of litigation, but it can also help to avoid, to increase the tensions that forensic combat produces. You know, that tension in court where people are looking at each other. These are people who have children together. These are people living in the same communities together, but the tension that comes with litigation in court, it is too unbearable. So if we can do a mediation where it is a win-win situation, better. So this brings parties together, narrowing the areas of dispute between them and facilitating mutual give and take formats. So it is typically more participatory. I'm talking about legal empowerment now. In nature, legal empowerment focuses principally on substantive and restorative justice and has the potential to enhance public participation in the justice system, respect for human dignity, and underlines the fact that we all live in a shared community. I think this should be, if we all live in a shared community, let us empower people, because when you empower people, if someone empowers people in a community within which you live, I think it is to your advantage. And you should thank the person who empowered the community. Because if we live in a community, in communities where people are not empowered, even when you are a legal practitioner, you are going to get problems. But the fact that we live in a shared community, let us try to empower other people. For example, promoting face-to-face encounters, dialogues between the parties, so as to facilitate resolution in public of their differences and restoration of harmony in the community. So I want to conclude in a few minutes so that I can hear from you and we have conversation on what I have been discussing. Sing it. Perfect. No, the conclusion is second of yeah, that's right. So apologies about that. I'm concluding in just less than 5 minutes so that I can also hear from others. So legal empowerment approaches to legal aid service provision is aimed at making the justice system more people-centered and efficient, where disputes are resolved quickly and efficiently, reducing the time and resources spent on litigation. Legal empowerment enables parties concerned to negotiate solutions to their disputes leading to higher satisfaction rates compared to court judgments. So judiciary is moving away from orating courts and re-engineering the alternative justice system to adequately cater for the justice needs of the people. This follows in line with the attributes of dispensing justice in accordance with the values, norms, and aspirations of the people of Uganda envisaged under Article 126(1) of the Constitution of the Republic of Uganda. Therefore, litigants should be in position to appreciate the entire justice system. It is not, they are not they, and we are not us. We live in a shared community, so we should, the litigants, the people that we live amongst, should feel a sense of dispute resolution rather than being thrown legal jargons only understood by those throwing them around, forgetting who is the end receiver of the justice system. We are not dispensing justice to ourselves. We are merely custodians of the law. All the stakeholders must play their part to realize the concept of legal empowerment for a better justice delivery system that is people-centered and responsive, especially towards the marginalized and vulnerable. So thank you so much for listening to me. We have some time. Over to you, Lynette. Thank you.
Thank you so much, Your Worship. This has been such an encouraging training, really. I'm thinking, what do I do in the sphere where I am? What can I do as a lawyer, as a practitioner, and even those that have really heading in that direction? Like, what are the practical steps that I can take, and how can I use and change my own approach? And so, thank you so much for this. It has been really, really eye-opening and very, very encouraging. And so now it's an opportunity to ask questions to the worship. And so the floor is open. Please put up your hand. And if you have some network issues, you're welcome to write your question or your comment in the chat. And so do not let this opportunity pass by. And I think especially for those who joined us from the FIDAUg Legal Aid, we have quite a number of our lawyers on the line. And please don't let this opportunity pass you by to learn from someone and to ask the questions that you have about the struggles you are facing as you do your very, very best to apply such an approach. And we know that the worship has a wealth of wisdom to offer to your very specific situation in the district where you are working. And so I see hands up from Susan Mamala, and then from Dr. Zara Nambu. So Susan, you're welcome. Glad to hear from you.
Yes, good morning, everyone. Can you hear me?
Yes, we can hear you, Susan.
Lynette, can you hear me?
We can hear you well. Please continue.
Hello?
Yeah, Susan, we can hear you. You can speak.
Okay, yes. Good morning. Your worship, thank you so much for this discussion. It becomes mind-blowing every time you are speaking with us. However, maybe to share experience on many times when we should not ascend so much into the arena and try to understand maybe the respondent. I think we have witnessed it in one of our cases. It was a court case where the man kept on insisting that he cannot afford a certain sum of money because he was sick. But I think together with court, it was like a push that you have to do this. And court passes the order. And as usual, these orders are not followed many times by the respondent. So we still keep on calling. Now, at the point of execution, unfortunately, the man dies. So he kept on saying that I'm sick, I can't afford. And we were not believing him, I think. We're not trying to understand him. So it's after now that he died that everyone was like, oh dear, sorry, I wish you get. So I really understand when you mention that. However, also in the clinic, some of the challenges we face around the alternative dispute resolution, which is very, very encouraging, is that the implementation of the orders or the consents that we come up with or the memorandums that we come up with is also very low. We negotiate, we agree, but for the respondents to implement, it becomes a little complicated. And then most times the option you have is to go to court. But maybe to report also, when we go to court and the orders that you give us, your worship, still the respondents do not abide by those orders. I think we've had so many cases of like that in the clinic, and we are left to wonder what else can we do, and then we start executing. Remember, by the time we have these clients of ours, the respondents are not those that maybe you can attach salary. It's someone who's doing a little business here and there, and there's nothing you can even attach from this person. And then the only mode you could be thinking about would be arrest. But then, as you said, being innovative outside the box, is there anything that we can do beyond the arrest? Because beyond threatening this man, even if we put him in civil prison for 6 months, he will come out and we shall sing the song again and again. So it becomes really complicated. Maybe for you to give us some guidance on what else can we do? Because even enforcing court orders is becoming a problem in the clinic. Even enforcing MOUs is becoming a problem by the respondent. So we are left to wonder, really, what do we do now? Because it becomes really, I don't know if you understand where I'm coming from, which I know you do. But also, the other thing I wanted to ask is that many times when we are having the negotiations and we're trying to understand the client or the respondent, remember we have to strike a balance, because the respondent could be like, I can only afford 300. Our clients are, she's telling you that guy has money. He can afford 1 million. He has this and this. Many things you cannot verify. Probably she's telling you, and then you're basing on the fact that these guys have been together like for 6 years, 8. So it's possible she knows him so well. But also, we might not take her word for it. And the respondent is saying, I can only afford 150. But the client is saying that actually he can afford 400. He has just built a house for this one. He has just done this. He has just done that. So maybe for you to help us strike that balance between having the interests of our clients at heart, but also being realistic. And you know that these are the clients sometimes that go off maybe social media to say that FIDA is not helping, FIDA is siding with the man, simply because you're trying to understand the man and be like, but this guy can only afford 300. How about we start with this and then we see how it works out, maybe moving forward, or maybe he'll get a better job. And the client, if you do not serve that interest of the 1 million, she'll be the one to run off to say that FIDA is not helping because now they are siding with the man. And these ones, we have seen them in the clinic, which I know you've also experienced at some point, of how, I don't know, the how is the question that keeps on coming back in all these scenarios. But the discussion around this is really, really mind blowing, and it opens our eyes every time you're speaking. We feel like we've spoken about it before, but then it feels so new. So it becomes so we really appreciate every time you come to inform us, people who are in the legal aid clinic. These are things that we need candid discussions on how best to do this work of legal aid, because it becomes complicated at some point. So maybe for you to guide us on those 3 scenarios, and we see how best we can move forward with the legal aid clinic. Sorry, I'm in the rain if there's some noises, but it's okay.
I think we have some network issue and like inoculation of Dr. Zara. So perhaps
Hello.
Yeah.
Hello. Good morning. Good morning, Lynette and ladies here. Thank you very much, FIDA, for this session and your worship, Roseline. We appreciate your worship for such an enriching and practical session that makes us see cases beyond the strict letter of the law. And congratulations on your recent award in defense of human rights. As FIDA, we are proud of you. Your win is our win. My issue is on how you handle cases that involve violence. Battery, gender-based violence generally. You're telling us that we need to be as practical as possible, try to steer these cases away from the court. But how do you handle these kind of cases where there is definitely harm, within the relationship? How would you steer these cases outside of the court system? If you can just share with us some of the practical steps on how to handle such a matter. Thank you very much.
I think those are two comprehensive questions to respond to. So I think I actually can go into those two. And then if there are any others, please do put up your hand. Please share them in the chats.
Okay, thank you so much for the questions. I will start actually that of Dr. Zahara Nampeo. Thank you so much for the message of congratulating me upon the award. I'm very grateful that I got an award. So how do I handle cases that involve violence, steering cases, these cases away from the court system? I think when I was explaining much earlier, I was like, it will be very, very important that we handle each case on a case-by-case basis. Because, for instance, a case involving battery, violence, how are you going to mediate that? I think my issue is we shouldn't generalize. We shouldn't generalize. We should give each case, we should work on each case within its own context. If it is a case involving violence or something that is way beyond, honestly, it cannot rape. There's some cases really. So for me, that is my response, is that I'm not steering cases away from the court system. No, just like the judiciary is pushing for ADR, it is not saying that actually don't file cases before the court. But what we are saying, what we are pushing for, is that there are cases that each case should be given, it should be decided on its own merit. We shouldn't generalize. Those which we think can be handled outside the litigation system, let them be handled. But those which deserve the attention and the audience of courts, please let those cases go to court. Like a case of violence, that one cannot be mediated in any way. I wouldn't actually encourage it. So I would also maybe respond to Susan Wamala. Court passes orders, and at times these orders are too outrageous. How do you implement? There's a question of execution. Susan, I want to bring it to your attention that even us at court level, it is a challenge. It is a challenge when it comes to execution. I will use maybe a minute or two to talk about my experience here in FIDA, that this has been an implementation of and enforcement of the MOUs drafted at FIDA Uganda. It is a very old song. Even when I worked in FIDA Uganda, I think those are 13 years back, and I worked in FIDA for 5 years. We had that issue. It was a song. It was a bad song, and it feels really bad that actually, even right now, it is still that song. And it is well beyond you, because, when you come up with the MOUs, it is up to until when there is that will of the other party, the other side, on the opposite side, who enforce them. Other than that, I think as the legal aid clinic, there are really limitations on how far you can go to execute them. So what happens when perhaps maybe you decide that no, this person is just refusing to enforce the MOU, so let us go to court. So what happens to court? Even when we are in court ourselves, personally, with all the experience that I gained from FIDAUg Uganda, with all the passion and the commitment. So I face the same challenge too. So someone is in court and you have had the matter to full completion. But now we have a question of enforcement. So what happens? And someone says, Your Worship, whether you do what or what, I don't have money, do what you want. So what happens? You don't have money? Okay. So we remind you. But at the end of the day, okay, we are reminding this person. And what goes through my mind is that, okay, we have put him, he's now a civil prisoner. But have we got the tuition that we wanted? And the answer is no. So I think that one we shall have to brainstorm and forge a way forward on it. But I think going forward, like today's topic, legal empowerment, I think we have to empower our women as much as possible. We have to empower them so that they don't become more victims all the time. That is what we are saying. Can we move away from being victims to empowered women? You came to FIDA as a victim. Can we empower you? Okay, someone is saying they can't afford. So does that mean you're not disabled? Even disabled people still work. They still cater for their children. But you have come to FIDA and you are an able person. All you are saying is that, tell him to give me the money. Okay, we tell him to give you the money. He's saying he can't afford. But can we also empower you? Can we start with that? For me, I think that is where we should start. If we are failing to implement, to enforce, and at times we really realize that actually the person does not have the money. The person cannot afford. So what does that mean? What does the law say? The Children's Act, the responsibilities of parents. So we have to tell this person that, you know what, it is also your duty as a lady, try to find what to do, so that as we are trying to push this side, let us not just have this child seated at home with a mother who is just waiting to go to FIDA Uganda to ask, has he deposited? Has he deposited? But what are you doing? Let us empower people. Let us empower our women. So, also another question, like, because I'm also speaking from an experienced point of view as somebody who has sat in the legal aid clinic and I have done the job myself. Is it sustainable? That is a question I used to ask myself. For how many years? Like, I left clients when I left FIDA Uganda to go and join the bench. I left clients who are depositing money with the cashier at FIDA. And this money was for maintenance, for school fees. But the question I always ask myself, is it sustainable? How long is it going to take? Does it mean when I leave FIDA, will this person, because we kept on reminding people, please, we are reminding you about your obligation. Last month you did not deposit. Can you? And I would ask myself, but for how long are we going to remind this person? The person would say, no, you know, I didn't have work last month. Now I've got a new job. They haven't paid me. And I'm like, the question of sustainability is inevitable in such situations. So even as we are working, we are pushing for maintenance orders, let us empower women. Let us urge them to go and work. Let us have a balance, let us be objective. Let us not just push women to become, you're the victim. Okay, you are a victim of circumstances, and then what? So we are going to go to court and then you're going to remain a victim until when? But let us try to empower them. Even as we are pushing court for remedies, can this one start up something? Can she do something so that the child does not just remain at home? The child is in a school, but still, even this side on the legal perspective, we are still pushing. But we are still pushing as we are empowering the woman economically.
Thank you very, very much for those responses. And do we have any other questions? Do we have any other comments as well? Because it's also an opportunity for really for discussion and conversation. If there's any comment from practitioners, I think those were all questions for today. Yeah. So that brings us to the end of our first session of two. We will now have a short break, and our second session will start at exactly 10:50. So it's just a 15-minute break, and less than 15 to just stretch our legs and get ready for the second and last learning session for the day. And yes, Your Worship, we are really, really grateful for the teaching today, for taking the time to come and share this very, very practical experience, and also this deep, deep passion that you have that really drives you throughout the course of your career. It's infectious, and I'm grateful that you are sharing it with us. And also, I think that sometimes reminding those that are in that position of providing legal aid, because people get tired, people get worn out, people get, it's difficult to hear so many problems and to work in conditions of lack day after day. So it's so important to have those reminders of why we do what we do, and to have that really ignition really of the passion and of really the care and love for the work that we work with. So we really thank you for that, and we really thank you for that and for FIDAUg. And also a very big congratulations from us as FIDAUg, and we will still be congratulating formally on our tactics, but well done on your award for judicial interpretation of sexual and reproductive health rights. It's also so close to our heart as FIDAUg, civil rights for women, and how the judges and the bench really considered that and adjudicated that. So congratulations for that recognition. We are in no way surprised.
Thank you so much.
And so that brings us to the end of session 1, and we will be back at 10:40 exactly. Apologies, we started a few minutes late. We just wanted to be all set up for our next presenter, who is Dr. Annette Mbogoh. And so Dr. Annette was actually with us last month when we were training on the use of a feminist approach to climate change in Uganda. So today she's back once again, and she's here in her capacity as the leader of FIDAUg, which is an organization that is very rich history in the provision of legal aid service provision, and who also uses a legal empowerment approach in the work that they do. I understand that FIDAUg also works with a great number of community legal volunteers or community paralegals, is what I believe the organization calls their community justice actors. And they have so many lessons to share from their perspective, and that really enables us to compare that to the Ugandan and the FIDAUg perspective really of how we do our legal empowerment work. And so Dr. Annette, you are most welcome, and thank you once again for joining us. Yes, so Dr. Annette will join us very, very shortly. And please do not leave the meeting. She will be with us in just moments. And our sincere apologies about this guy. So as we wait for Dr. Annette to join us, allow me to share a bit of information about the modalities of our new and I believe improved way of doing CLE training. And so those of you who've been with us throughout this journey, and I think I recognize quite a number of names and faces, and would know that we often have about 4 hours of teaching and 1 hour of group work, and that constitutes of 5 hours of CLE training. But today we decided to do things a little bit differently and to test it out and see how it works. And so, yeah, so our plan for today is to have 3 hours of teaching, of which 1.5 hours have already been completed now with Nsenge, and then to have another hour and a half of teaching with Dr. Mbogoh, and at which point you will receive a take-home assignment. So there won't be group work, it won't be a group discussion, and it would be an opportunity for our participants, and particularly those who wish to earn CLE points, to do some individual work and written work from 12 p.m. and we give a deadline of up to 3 p.m. Although I don't think you would need 3 full hours to do this kind of assignment. And then you will be expected to submit this assignment back to us over email with a deadline of 3 p.m. And that would also serve as the post-training evaluation, as there are some questions that allow you to reflect on how you can change your practice and do things perhaps a little bit differently as a legal aid service provider and even as a lawyer in practice. So that would be really our modality for the day. And I hope that it will, yes, I hope that it will be a good learning experience. We are very open to feedback and to know which training methods our participants and our trainees prefer. And yeah, we could perhaps just continue to shape it up a little bit and to have interesting and different ways of doing these CLE trainings, and especially for as long as we are online. And we do hope to grow our academy up to such an extent that we are able to host these trainings in person, and because we feel that they're really inspiring, being in the same group and being able to meet together in the same room and really learn in that way. But for now, we really make the most of our online platform, and we thank you all for joining us here. And so, Dr. Annette, are you able to join us now? Are you able to read your session? So I think what we'll do is allow me to share and run through with you with our online let me share a link to the take-home assignment that we'll be doing this afternoon. So if you are able to open the link that I've just posted in the chat, and that will take you to our take-home assignments. Actually, the motion, my screen.
Okay.
Actually, my screen. So everyone should be able to open the link, and that will take them to the take-home assignment. We are also sharing it over email for everyone who had registered ahead of the training. And yeah, so there are two parts to this assignment. Yeah, and I see some people are joining me in the document, which is excellent. So the first task is a case study with a certain number of questions that we'd like you to answer. And so the first task is a case presentation, and you can read it. So the case presentation is that you are a lawyer working at Justice for Women, which is a fictional organization that is similar to FIDAUg Uganda. And this is a legal aid center in Kapchorwa. You are approached by a client, Rehema, who is a single mother living in a rural area of Uganda. Rehema's husband has recently died, and she is facing eviction from a family home by her deceased husband's relatives, who claim they have legal right to the property. Rehema has limited understanding of her legal rights and no financial means to afford legal representation. So your questions in your take-home assignment will be the following. The first, focusing on legal strategy. And we'd like you to outline possible legal remedies that are available to Rehema and the steps that you will take to address the situation. Then, the legal empowerment approach. How would you incorporate legal empowerment principles into your approach? Specifically, how would you ensure that Rehema is informed about her rights and involved in the legal process? And then thirdly, community engagement, which we know is a very important part of legal empowerment. Suggest ways to engage the local community to support Rehema's case and to raise awareness about women's property rights. And so those are the three questions that you want to answer under task A. And then task B, which is the learning and reflection, and that also serves as like a post-training evaluation, and would be to write a brief reflection that does not exceed 700 words on how this training has influenced your understanding of legal empowerment and your approach to providing legal aid. You can outline personal actions that you plan to take to apply the principles of legal empowerment in your own practice. And so those are the two tasks, and they will be due either in Word or in PDF. And the length of the entire task should not exceed 5 pages, but it can really also be shorter than that. And the deadline is 3 p.m. today. You are to submit this to myself and to Alice Kathleen through those 2 email addresses provided. And yes, and we will try this different way of learning, and I think it's going to be and I believe it's going to be quite effective. And so I also believe that we are now able to move on to our second session. And allow me once again to invite Dr. Annette Mbogoh to lead the session on legal empowerment and really from the perspective of working with community justice actors. And so Dr. Annette, we are looking forward to hearing from you, and the floor is yours. Seems we may still have the same network challenge. Kindly bear with us, and I think we will be able to sort it out. So we are facing technical difficulties, and it's always a little difficult if we expand our pool and we invite facilitators who are facilitating from outside of Kampala and outside of the country. And so Dr. Annette is facing some challenges with her device, and we believe that we'll be able to sort this out in just a few minutes. Please be with us, and please stay in the room, and we will be back as soon as she's able to start presenting. I also see apologies about this.
going for that prayer?
It's today,
Are you going
from
for
what I
tomorrow or
heard.
tomorrow?
Hello.
I hear you. We're very glad that we were able to hear you.
Okay, sorry about that.
Okay, wonderful. Yes, so let's leave them into our second session, and Dr. Annette, over to you. Thank you so much.
Okay, thank you so much. Technology sometimes can really mess people up. I was here like just before the judge had finished presenting, but I'm happy that it has been sorted out. So my name is Annette Mbogoh, as Lynette has told you. I work at Kituo cha Sheria, that's a non-governmental organization that focuses around access to justice. And I'm glad to be here again for this session, where I was asked to speak about strengthening community members and community paralegals through a legal empowerment approach. So in terms of the structure of my presentation, I'd first start by giving an introduction and then defining the terms. I'm not going to too much in depth on that because I saw that the previous presenter did touch on that. And then I look at the cycle of legal empowerment and then give very practical examples on how you can apply the legal empowerment approach and the cycle in terms of knowing law, using law, and shaping law. And then I'll close with a few examples from our own organization in terms of how we adopted the legal empowerment approach to empower communities and community paralegals in specific cases that we handled. Now, before we start, I had a very simple exercise that can trigger our discussion today. So I don't know whether that can be displayed on the screen. And I have a question. The question is, what do you see as the top reasons why injustice persists? This is a multiple choice question. So there are those different reasons that are listed there. A, is it that there are not enough lawyers to represent the people? B, is it that the court systems are too slow? Is it that the legal system is set up to benefit people who are already in power? D, is it that people directly harmed do not have the knowledge of the law? Or people directly harmed do not have enough power to create change? F, is it that information about the law and the legal system is not user or child friendly? And G, is it that women and girls fear reporting GBV cases to police and community structures due to the negative reactions from community members? So just maybe I would like to hear from maybe 3 of you as to which choice you would pick. You can only pick one choice, and why you would choose that particular response. So the question is, what do you see as top reasons why injustice persists? And there are those options outlined there. And maybe 3 of our colleagues on the call can share why they've chosen a particular response.
And so who would like to share? You're welcome to put up hands. I see Annette has, would like to share her choice and give reasons for that.
Yes, good morning to you all. Me, I would go with F. Information about the law and the legal system is not user or child friendly. Why? Because of the very many clients that we see that they have suffered injustices in their communities because of lack of the legal knowledge or even the lack of the procedures in the legal system. Even when they go to court, they are misguided by these clerks. So you find that there is a lot of missing information that they don't know about, even the procedures, where to go, which person to run to, all that is missing. So I would go with F. That's why the injustices are still persisting. If everyone was empowered enough, at least we would have seen that the percentage of people who know the law or who know the procedures or even who know their rights and where they can run to has increased. Thank you.
Thank you very much, Annette. Any other contributions? So Annette goes with F. Any other person with a different view? There is no right or wrong answer. All answers are correct, actually.
All right, I will give it a try. I would go with G. It states that when adults reports will give you cases for this structures into the events interactions from a community level. And I stick to this point because we realize that even coming from a traditional society, there's still some people who believe that, it's okay for a man to beat a woman because it's showing affection and love towards her, and so she should embrace it. And yet, at this stage, you're seeing someone being harmed, or that girl being harmed. And so, just a negative reaction from how that to perceive such actions, for me, I feel would really fall into that top reasons as to why injustice persists.
Yeah, thank you very much. So G, the fear of reporting due to the negative cultural reactions. Could we have one other, thank you very much for that contribution. One other contribution on what you think is the top reason why injustice still persists in our communities.
You and mine would be actually number E, because I think it's really an issue of power. And if you have power in your society, in your community, then you can also ensure justice for yourself. But if people who are very beyond and do not have that power to ensure change, to ensure retribution, and it just means that injustice persists.
Okay, thanks, Lynette. So I think the legal empowerment approach that you've discussed the whole of today is one of those approaches that tries to also dismantle the power structures within our communities so that we are able to empower communities to know the law, have information about the law, as Enid had said, and with this probably also counter negative community reactions or cultural practices that still keep us within that cycle of injustice. So we can move on. So I think I'll reflect mainly on our experience in terms of us as when we were young law students, is that we were taught that the law was at the center of everything. Everything emanates from the law, everything starts and ends with the law, and that the law is actually an expression of our societal values, our morals, and the foundation of our cultural setup. And this kind of approach to how we viewed the law and how we were taught about the law also had an implication and an impact on how we apply the law and how we interpret the law when it comes to day-to-day disputes. So how do we view the law as a tool to resolve day-to-day disputes, and also who can use the law as a tool? And so because of the kind of training that we all get when we're in law school, we always think as lawyers we have the solutions to all the legal problems. And yet, even the question of what is law is a very contested question, especially within African countries that have gone through colonialism and have had to co-opt principles from colonial masters, such that now we have plural legal systems that incorporate both formal law, the law that we know is written, and also informal law, which is influenced by our African customs and practices. So we find that the history that informs how our legal systems are created really in many of African jurisdictions up to today greatly impacts on legal empowerment approaches, how we view law as a tool for driving development or also driving change within the continent. So from that, I found that it's important to see law in its plural nature, even as we contextualize legal empowerment. As Lynette has said, when you talk about injustices, you're thinking about the power structures. So law in itself as well demonstrates power, it demonstrates control, and it demonstrates regulation. And the power of the law, I'm sure all of you here are feminists and ascribe to certain feminist ideals. And a lot of feminists argue that that women's oppression has been anchored within the power of law. And we say that law has power because it dictates how we should act, what is right and what is wrong, and also regulates our conduct. And when we say that the law has power, it's also coming from who makes law, and law here being made mainly by legislatures who are men, interpreted within judicial systems that are mainly male dominated, and enforced by executive systems of government that may also be male dominated. So in terms of the power of law, the law power is pervasive. It can be positive power, but also it can be negative power. And the reason why law becomes powerful is because it dictates a standard by which everyone must abide by. And we have seen also the law being used as a tool by the powerful to subjugate the powerless. And this happens across the world, not just within our countries today. And we've also seen powerful and influential people within our societies today being treated very differently from the powerless. And we've seen that the justice system itself, especially if you go into prisons, for example, I'm not sure about the situation in Uganda, but I know in Kenya that a number of those people who are in prison today in remand are people who are poor because they could not raise bail or bond and were probably caught up within the justice system arbitrarily. So the law has also been seen to maintain status quo through its selective application, and poor people have been harshly charged, prosecuted, imprisoned by broken justice systems for the benefit of powerful and influential people who do not end up being caught up in our system. So the whole issue of the rule of law is still something that we are struggling with up to today. Whoever is, I'm not sure whether the slides are moving, but I'm now in slide 6, so you could move forward to slide 6. So in terms of defining concepts, so legal empowerment, and I'll not stress much on this because I know you have already discussed this earlier on. Legal empowerment becomes a very important approach because it tries to equalize the power imbalances that have been brought about by class, that have been brought about by gender, by age, by religion, by race, by culture, amongst many other variables that you can think of. And what it seeks to do, and we'll see through the examples, is to transfer power to the powerless using the law as a tool, and the law being used as a tool for social transformation. And I think this is one of the really important aspects of legal empowerment approach because the law is used to create social transformation and also sustainable development. And the legal empowerment approach is anchored on the whole idea of the power of the law, but channeling this power to positive use so that you can dismantle systems, you can dismantle barriers and ensure that there is access to justice and create a just and equitable society. So if you look at how the legal empowerment views change, it views change as a cycle. And I think when we started, we asked what causes this persistent injustice? And what can we do to break down this persistence of injustice? And so it's all within a cycle that is provided for under this approach, is that first, if communities know the law, then they are empowered to use the law. And as they use the law to advance their agenda, then they will be able to shape the law. And shaping here means that if they encounter a law that is bad or a law that is not responsive to their needs, they're able to influence that and shape that law in their own interest. So in simple terms, is the mantra of legal empowerment is that you know law, use law, and you shape law. And at all times, the law should always be responsive to the needs of the people as opposed to people responding to the law. So it's a really very radical way of looking at how law should work and how law can actually change the societies that we live in and address systemic injustices. So we can move to slide 7. So legal empowerment is about making law accessible, putting the power of the law in people's hands, putting people at the center of the law. And it's a process that builds the capacity of people to know how to know the law, use law, and shape the law. And anyone or everyone can follow this very simple path, and you don't necessarily need to have a legal background. And I think this is where the issue comes in terms of how different do we apply a legal empowerment approach when we work with communities and we work with community paralegals. So in a lot of the times in the sector, if we move to the next slide, we find a very an idea that is really used a lot in our discussions, in our reports, is legal aid. And I thought before we go into how, for example, Kituo has done it and how I've experienced the use of legal empowerment is to just distinguish legal aid and legal empowerment. And I think these two are two totally, they may be related, but really distinct ideologies and philosophies. So when you talk of legal aid is an approach that is centered on the legal practitioner. So on us as lawyers, anchored within a formal justice system, and such that without a lawyer, without an advocate, then there can be no aid. So in a sense, legal aid is more service oriented. The communities come to the lawyer for assistance. The communities cannot do without the lawyer. And the communities need the lawyer so that they are able to access justice. And I'm not saying you are not able to attain results with this approach. You will attain results, and we've seen cases can be won in this kind of way. But the problem with legal aid as a philosophy is that it's not sustainable. And we are always having to think of where we'll get the next funding or more resources to continue to provide this kind of services. For those of us who have been within the sector, I think we all know how difficult it is to raise funding for legal aid work. And this is why legal aid then becomes quite difficult to sustain. And so when we adopt this approach, whether whether it's government or whether it's non-state actors, it also limits the extent of our results and how much we can do, because if there's no lawyer, then there's nothing much that can be achieved. On the other hand, the legal empowerment approach is centered on the communities themselves, whether the communities are here, communities that are undergoing a certain injustice, or where you have community paralegals. And these communities and community paralegals are seen as partners to the journey of justice. And people who have agency also to be able to contribute to the resolution of their justice challenges, so long as they are given the requisite tools. And I will later on we'll discuss how you would impart this kind of requisite tools and the processes that would be involved in that. So under legal empowerment, it's more sustainable. You're building capacities, sharing information with communities, with community-based paralegals, so that they know and understand the processes. They can navigate these processes with or without the lawyer, and through that find their own justice solutions, obviously within the purview of the justice system in their respective countries. So you find that the legal empowerment is development oriented, cost effective, it's scalable, and the results are much, there are more results in terms of how far you can go with very few resources. I'd like now to go to the 3 steps in legal empowerment. So that's in the next slide. And we'll start with step 1 and then see how do you effect step 1 as a lawyer who is working with communities and community paralegals. And let me just correct, just because I know sometimes this whole idea can be quite controversial, is we are not saying that there is no place for the lawyer. The lawyer plays still a central role within a legal empowerment approach, because still lawyers have the knowledge of law, having been trained in the law. So they play that role, but they do not do this alone, but in partnership with communities and with community paralegals. So can move to slide 10 on know the law. Sorry, the previous one. So I said there are 3 steps, and the first is knowing the law. So what is your role as a lawyer or an advocate when it comes to this step within the legal empowerment cycle? So in terms of knowing the law, your role as a lawyer is to help the communities, help the community paralegals, help communities that are at risk or diverse populations that includes women and children and persons with disabilities to understand the law, to discuss and explain how these laws affect their lives. And this is something that is not done once. This is a continuous effort that is that would require several educational sessions, because as a lawyer, you need to ensure that the people that you're working with are able to apply this legal knowledge in their life. So the knowledge of law is not supposed to be a preserve of just lawyers, but of everyone. And we all know that ignorance of the law is no defense. So it's important that communities are able to know what the law provides, understand it, know how it impacts on their lives, and also know how they would apply it in their respective lives. And this is one of the things that as a lawyer you would need to do as you work with communities and also with community paralegals. Now, I think in terms of continuous effort, and we've seen with our working with community paralegals that it can't be a one-off training and then you disappear as an institution or as a lawyer. For us as lawyers, we've been trained as lawyers for 5-6 years, and even when we're in practice, we are still learning. So you can imagine how much more education does the community need, especially when we are talking about marginalized and indigent communities that may also not be literate. So creating a sense of legal literacy requires patience, it requires time, it requires continuous effort and perseverance, so that you keep on sharing that information, sharing that knowledge until people are able to relate with the law in terms of their day-to-day lives and also apply it. And at Kituo, what we do is when we train community paralegals, the organization gets into relationship with the paralegals that are organized within community-based organizations, and they form part of a network of organizations that work with Kituo cha Sheria. And Kituo cha Sheria gives continuous legal education as and when resources are available, whether it's done virtually or in person. And I think when we did research last year, one of the things that our community paralegals found particularly important for them was the need for continuous training and continuous capacity building and knowledge building. So I think the need for you as a lawyer to equip community paralegals and communities themselves with this kind of knowledge is absolutely important. So to provide this service, next slide, to provide this service in your community, you need to do the following. Again, these are just my suggestions, so I'm open to hearing other suggestions from the rest of the group. So first you need to know law, both formal law and informal law. And I think from what I said initially, especially within our African countries, we cannot just stick to the formal law that we know, but also informal law, because it plays a very important role in the day-to-day lives of grassroots communities. So you need to then know formal law, know informal law, know the practice, know its consequences within the community, and also understand the communities that you're working with very well. And most of the times, as lawyers who are working with communities, we may come from those communities, but even if we don't, with time we gain some kind of understanding of the needs that are within that community and how their needs relate to the respective law. The other thing you need to do is to understand the best and most culturally appropriate way to provide legal awareness services in your community, and also be equipped with skills and techniques to apply those approaches. So once you've understood your community, then you'll know what is culturally appropriate for this particular group that is not for another group. And then you're able to design your legal awareness campaign in a way that is useful to that group. So for example, if you're working with a community that is very gendered, very culturally insensitive, if I may use that term, you may want to see how you can do legal awareness trainings that are for women alone and those that are for men alone. And once you've built a sense of partnership with that community, then you can do mixed legal awareness sessions so that you have both men and women being able to openly share within those spaces. In other times, you may want, if you're having a legal awareness session with children, you may want to look for a child-friendly space. You may want probably to have it at the classroom where the children are safe, or at the playground. It really depends on what you think would be most appropriate. And in other times, group discussions may not be the best. You may want to use a door-to-door approach for your legal awareness campaigns, so that you're able to target your audience appropriately. And now within this new era of technology, maybe the best avenue is actually online. So whether it is through the social media platforms, if you're targeting a certain group, maybe the youth, as opposed to using in-person legal awareness campaigns. So as you are doing your legal awareness campaigns, think through the culturally appropriate ways to provide these, specifically looking at the target communities that you have in mind. So the other part of the cycle is use the law, the next slide. And so using the law, this is where we practically apply the law. So what would be your role as a lawyer working with communities and community paralegals here when it comes to use the law? And here I'm sharing an example where you have a marginalized community that has a pervasive practice of early marriage. So you're working within this community, you want to stop early marriage within this community. How do you use the legal empowerment approach? Probably you would have been doing a lot of legal awareness under no law, and now under use the law in the next step, what you would want to do is to work, for example, with the young girls or with the women, so that you can figure out what the law says and find a legal solution to that problem, and how the law can be used to resolve that problem. And getting legal solutions to a problem can include probably writing a demand letter to the relevant authorities, probably deciding whether dialogue can be used in that particular instance, looking at the options of going to court, and also whether the community itself would want to highlight some of these issues in the local media, can be mainstream media or also can be social media. So it is important that whatever solution you identify, that it must have been co-created. So co-created with who? Co-created with the community that has been affected by this injustice, so that they can also contribute to finding of a solution, and that they also fully understand how the law would work for them in that particular situation. Sometimes, and I've seen especially colleagues who work within the private practice, and I say this from the Kenyan experience, maybe it probably does not happen in Uganda, but in Kenya, when a private practitioner gets a client, the instructions are given. The instructions are given to him or her, and the lawyer says, okay, those are your instructions. They decide what approach they will use. They do the letters, file the pleadings, and sometimes some may not even update the client on the progress or outcome of the case, even when judgment is entered. So the client almost becomes like, almost used throughout the process and only comes in maybe to give evidence. And finally, at the end of the case, should if that person is a good lawyer, they would be kind enough to share the judgment. And also, for the really bad lawyers, they may not even pay them the award if it had been granted by the court. So the legal empowerment approach here requires us to co-create the legal strategy, co-create the legal advocacy approach that we'll use, and enable the community to understand how that law will work for them in that particular situation, and also find solutions to the injustice that has befallen them. So in the next slide, as a lawyer who is using, in this aspect of using the law, you can guide the community or community paralegals to use the law as per the example that I've given, or where an individual is requesting for legal advice or assistance. And your main role is to understand with the group or individual what are the barriers to access the specific rights, and with your legal knowledge and competencies, as well as with the support of your network, you will then try to find solutions to mitigate and eliminate those barriers. So you can thereafter provide specialized legal assistance that is based on your knowledge and the law and the context. So for example, filing a particular case in court, providing legal representation in court, accompanying that particular individual or group to the formal administration or maybe to the police so that they can get the assistance that they require. And where you find that this individual or group requires further specialized support that is not legal and that you're not able to provide, then providing, or rather making the necessary referrals to an appropriate institution or individual that can provide that specialized support. So a good example here would be maybe therapy or counseling services. So we as lawyers may not be counselors. So we may now refer such kind of cases to professional counselors. So that is use the law. Finally, we come to shape the law. So shape the law, that's in the next slide, is the final stage within this cycle. And actually, it doesn't mean that legal empowerment stops at shape the law. So as you shape and change the law, the cycle starts again, because then you have to inform the community accordingly of this change. And sometimes even when law is shaped or changed, implementation may not be as fast as we want. So we want to continuously keep on informing the community. The community continues using that law and continuously shaping it. So it's a cycle that goes all round and round. So under shaping the law here, what we are saying is that you, together with the community and community paralegals, will embark on a justice journey. And as you do so, where you're knowing and using law, you're also documenting your experiences, individual and collective experiences. And these experiences, together with your legal knowledge, can actually be used to get institutions to move or to shift or change their way of doing things, and also to bring about policy and legal change. And this is what we mean by shaping the law. So therefore, in the next slide, shaping the law can take very many different forms. So in some contexts, shaping the law can mean you're challenging a law that you feel is unjust, or you're pushing for amendment of a law, or you want to develop a new law because you found from your experience through this justice journey with your communities and community paralegals that there is a need to develop a new law or to repeal an existing law. So shaping the law can constitute either of these forms. Shaping the law can also constitute supporting the communities to identify barriers, to seek and access their rights, and also to help them to organize and demand their rights through very many different forms. We've already spoken about these forms, whether it's them writing a letter, requesting for mediation, organizing a protest or a procession. Kenyans, we are good at that. And many other things. It will all depend on what you and your communities feel will be the best way in which you can demand for rights. So based on your context, obviously. So one other aspect of shaping the law is to allow the community itself to identify what are they seeing as their barriers to access their rights. And they can only do that if they have an understanding of what their rights are. And that's why the other two steps, as that we've already discussed, are very important when it comes to shaping the law. The other form of shaping the law can be through requesting of local dialogue with traditional authorities, local authorities, or even a group within the community that is actually the barrier to accessing rights. So if you work with communities, you will find that sometimes communities are divided and that the problem may actually be within the community itself. So it's not always that the problem is the state. There may be some problems that emanate from within the community that then hinders progress. So when it comes to shaping the law, identifying, for example, the barriers within the community and maybe calling for a dialogue can enable certain processes to move and build a sense of unified front within the community itself. So those kind of processes as well are still what we consider as shaping the law. So these are just examples of how the law can be shaped and what your contribution would be within that process as you work to build the community's capacity to bring about this kind of change. And I think one of the things is to always be conscious of our own biases as lawyers, especially lawyers working with communities and community paralegals that are very marginalized, is sometimes we think we have the solutions to everything, that we are the fixers and that we are the people who know the law so well. But I think coming to our communities with a spirit of humility does help, in the sense that you may find that some really brilliant ideas on a legal strategy can actually come from the beneficiaries of that process itself. And I think one of the, a good example I would share relates to some of the public interest cases that we ourselves as Kituo have done. Initially, we used to do a lot of our public interest litigation work with lawyers alone. So we'd have caucuses amongst the lawyers in-house, bring in external counsel as well, and write up the pleadings and submissions and etc. But would not engage the community in those stages that were relating to discussions around the issues, the legal issues and the issues emanating from the community. And we found that to be a really elitist approach from our own legal standpoint. And so what we started doing was that we would, even during the caucuses with external counsel, would invite some of the clients, representatives of the clients, to those meetings. And it really helped them to also, it helped both sides. First, it helped the lawyers to actually see how this legal problem was affecting that community and how it was affecting them. And so when it came to identifying the actual legal solutions, it was much easier for them from a point of information. But at the same time, it also helped the communities to understand why we were taking a certain approach, how we were taking this approach. And sometimes where they would say, no, we don't want this kind of prayer. What we want is compensation. We don't want, so what we want is land. We don't want compensation. Then even in terms of how we would draft our pleadings would be influenced by really what the community wants. So I think the importance of just being aware of that and knowing that solutions can actually come from our paralegals and from our communities is an important consideration to make. So in the next slide, I'm just looking at why, again, just to reaffirm why legal empowerment as an approach is important, is that it's also connected to the broader development agenda. And I just gave this example of UNICEF here, where you're looking at birth registration as a right, and UNICEF doing a lot of work around training health workers and teachers so that they understand the legal regime around birth registration within the country of Bangladesh. And as a result of that, professionals then could register children who came in for immunization for primary school enrollment. And this resulted in not just easing of access to birth registration, but also getting children whose families may not have sought out legal services at all. So I think the legal empowerment agenda is important because then it connects to the broader development agenda. Again, also it's important because it builds power, and we've already discussed how that happens. And as lawyers, instead of saying, I will solve this problem for you, what we should be saying is that we will solve this together. And when we are done, you'll be in a better and stronger position to address similar problems like this in future. And just to give an example here, is in around 2013, Kituo filed a very interesting case on the right of inmates to vote, or prisoners' right to vote. And this case actually was initiated because of our community paralegal work within the prison, within the prison centers. And the inmates who were trained as paralegals made a specific request to the then executive director of the organization that they want to participate in the elections. And this was during a time just before we were going into the elections. At that time, there was, I wouldn't say it was a gap but our constitution was silent on who could participate in an election. And so we found that this may actually be the opportune time to test our constitution, based also on the request that had been made by prison paralegals who we had trained and who had now become legally conscious, and so could identify where the gaps were and what rights they could have. So it's on that basis that the case was filed, and this case, filed jointly between ourselves and them, had a positive outcome in 2013. And actually in those elections, prisoners in Kenya did vote for the presidential election. They didn't vote for the other positions, but they voted for the presidential elections. Fast forward to I think it was 2022, not 2017, but 2022, just before the elections then. So the paralegal program in prison continued even after that. The trainings continued, the capacity building continued within the prisons. And these paralegals, and now some of them had left, there were new ones, but they felt when the recently concluded elections and were just about to begin, that they were not going to participate in the elections of the other elective seats. So what they did on their own is they prepared, they did a draft petition, shared it with some of our legal officers. The legal officers reviewed that petition and they filed this petition in their name, in the name of the inmate who was taking lead in this. And the court actually decided that in the next election, which will be 2027, that all prisoners must vote for all the elective seats. So not just the presidential election, but all the elective seats. And so you can see our input when it came to the second petition was really almost nil, but the paralegals themselves were able to organize, rally, support, do a draft with the support of the legal team, and file a petition in court and finally get a decision on their own. So even if you look at it from the point of cost effectiveness and also the sustainability and scalability, that legal empowerment may actually be better. So when you're talking about building power through legal empowerment, the same principle applies when we work with children, for example, and we are talking about the child participation principle. So it's the same thing when you look at our communities and our community paralegals as a lawyer, is that you're facilitating the child's participation in matters and decisions that affect their life and empowering them even after they've experienced a protection risk so that they're able to face a wider system and also know how to navigate a similar system. So justice is a journey that is taken together with the community or client. Each step is an opportunity to legally empower the community or the client in the search of a legal solution. Decisions are made together and there's an exchange of ideas. And individuals or communities who work with lawyers in search of justice learn about their rights and they're able to begin to use the law. And in return, they support other community members, creating ripples of empowerment. Before we go to that, please go to the last slide. And then I'll return back to another slide so we can, yes, there. So I've already talked about the prisoner's right to vote case and just wanted to talk about two other cases. One is on the closure of the Dadaab refugee camp. And what was interesting here in terms of using the legal empowerment approach is how this case was handled and the outcome of this case in terms of building up on this cycle that I've spoken about. So in this case, quickly just to give a brief background, is that the Kenyan government wanted to close down one of our, actually not one, but the largest refugee camp in Kenya that would have resulted in over, I think around 200,000 or so refugees being returned forcefully back to their home country, and a lot of other disruptions that were of international human rights concern. And so when the directive came, the institutions that would have protected refugees were not able to do so for whatever reason. And so we came together and we decided we were going to challenge that directive in court. Before we did that, we had engagements with refugee-led organizations. Some of them were working within the Dadaab refugee camp, and others were working within the urban centers. And a lot of them were not even aware. They just had heard through the grapevine that these were the plans government had, but they really did not know what and how this directive would be implemented. And obviously there were fears that they had about being returned home. So we had conversations with the refugee-led organizations. They were definitely not happy with it. And what we thought to do is to bring a human face before the court. Is Kituo as an institution couldn't file this case on its own. And so we spoke to the refugee-led organizations, some of whom we had trained as community paralegals, refugee paralegals, to identify their fellow refugees who are going to be affected by a closure of this refugee camp, and ask them whether they would be willing to be part of the case. So they did identify, they identified 2 refugees who are willing to take the risk, and it was a huge risk because then their names would have reflected in the pleadings. They had to swear affidavits, and we all know when you're filing cases against government that this is a risk, and more so a risk for a refugee client. So they did agree to go through this process. They swore affidavits, we filed them. They swore affidavits alongside myself as the director of the organization, and we filed the case. And the case went through it was just decided this year, early this year. And throughout, when it came to, looking at how would file the case, the legal strategy, even as the case was going on in court, would have conversations as lawyers, yes, but then in all these conversations would have refugees present who would then be able to share this information also with the broader refugee community that they interact with. Finally, when it came to the outcome of the case, we won the case. But what I found particularly encouraging is the decision of the court, where the court said that when it comes to any decisions that relate to refugees as stakeholders, that the state has an obligation to ensure that they are engaged, that they participate in the process of developing policies or plans that will directly affect them. And so that right of participation is not a right that only extends to the Kenyan citizen with respect to its government, but it also extends to the refugee who has been recognized as such and is being hosted within Kenya with respect to the Kenyan government that is making policies that will affect them. And so if the court would make such a decision in relation to refugees, then I think the spirit of the decision in itself has a legal empowerment spirit, in the sense that let everyone be engaged in the process of finding just solutions. Lastly, is in the case of right to digitize justice for indigent clients. And this case was filed at the height of COVID, when all courts had to be closed down. And so we had to use online court, as I'm sure all of you had. But this had a huge implication on poor clients. And so what would happen is that some of the clients who would come to us who are not represented by advocates would be conned by cyber cafes that would ask them for a lot of money just to open an email account. They'd also not know how to navigate the judiciary's e-filing platform. Some had no idea how to, how to find or access internet. They had no smartphones, no laptops, nothing. So it really put, especially the elderly litigants, in a very bad position. And so when we filed this case, we were telling the Chief Justice to either open the courts, very controversial prayer at that time, or for the Chief Justice to come up with a mechanism where indigent clients can approach the court at their own time and find these and able to be accommodated, get internet access through the court, and thereby attend to their court matters. So in this case, the judge agreed with us and actually gave an order to the Chief Justice to put in place mechanisms to ensure indigent clients are able to access justice and access digitized justice. And since then, there have been discussions around how this can be done in a way that is more people-centered and more open for every person. And again, this was one way in terms of how we got the experiences from our own pool of clients based on how they had experienced the court, and they also shared their, how they experienced the e-filing platform that formed part of the claims that we made before court, and the court found that those claims were actually true and made orders accordingly. So as I close, please go to slide number 18. We'll ignore question number 1. Sorry about question number. We'll ignore question number 1, but only look at question number 2. And is based on what we have just discussed, do you see any similarities with your work, or do you see any differences? And so this is just a reflection on your own work, on your context, and how you see legal empowerment and how you understand legal empowerment to work within that context. If there's something that I have shared that will probably inspire you to do things differently, or has reaffirmed the way you are doing your things that may have been different from how others do it when you're providing legal services to our clients. So basically just a reflection, and Lynette can help me get a few reactions from the group as I end my presentation. Thank you, Lynette.
The way that you shared your perspective in such a, in such a broad way. And I think it was really very enriching to think about the fact that, legal empowerment is, it's really a very, very broad approach that affects, that affects the way that people access justice at these various levels. And it's something that we can actually incorporate in how we do our work through strategic interest litigation, but also through how we interact with our own clients. It's, it's really incredibly. Lord, I'm grateful for the way that you've shared the experiences and you've covered all these different aspects. And so at this point, I would like to get some feedback from our participants on the question. And if everyone goes, please display the question still that Dr. Annette has asked. And that is how, like, reflecting on your own context, because of course now we have shared with us, mostly from the Kenyan context, which we know has many similarities to that of Uganda, but are also different in a number of ways. And I think particularly in the way, in the level of freedom that people receive, and to enable them to advocate and to fight for the recognition of their rights. So we would be quite interested to hear at least two reflections. And I think this could perhaps come from particularly our legal officers who are in the room. Victoria, would you perhaps be interested to reflect and share with us what are the similarities that you see between what Dr. Anita shared from the Kenyan context, and do you feel that you now define or understand legal empowerment differently? Having attended this training, and also I know many of you have also attended some trainings with the Legal Empowerment Network, which also contributes to really shaping this view and the kind of approach you have to your work. And so that can hear perhaps from Claudia, Victoria, and Susan, if any of you can share your perspectives. As we wait for our participants from and as we wait for some responses from our participants, and allow me to repeat the instructions for the online take-home assignments. So I've shared this a little while ago, but let me just repeat it for those who may have not been back from the break at that point. And so if you follow the link that I'm posting right now in the chat, and this will take you to your take-home assignment. And this assignment is due at 3 p.m. So just after the break, we ran through the instructions in quite a bit of detail. But this is just another reminder that this assignment will be due at exactly 3 p.m. And this is a requirement for you to be able to earn CLE points for your participation in this CLE training. So please be sure to submit it over email at least by 3 p.m. Though I don't think it would take you much more than an hour, maybe 2 hours at most, to complete this assignment. All right, but at this point, I really would like to hear back from our participants. Victoria, Claudia. Susan, can any of you give us some feedback on Dr. Anita's question? And like, how do you compare your own context and your own experience to that which Dr. Anita shared and described about from their experiences in Kenya and from this legal empowerment journey that I've been embraced in the country, but has also been spearheaded by Kituo Sharia for the past many years. So you're welcome to put up your hand or to share the chats. Otherwise, I think this really brings us to the end of the formal training part of today's session. And so, once again, I do sound like a breaking record, but please be sure to complete your written assignments and to submit it to myself and Kathleen by 3 p.m. today. And that will ensure that you're accorded CLE points. And thank you very much for being with us and participating. And also a very, very big thank you to you, Dr. Annette, for joining us once again. And something interesting that I just learned last week about really the history of FIDAUg Uganda and Kituo Sharia. Is that FIDAUg Uganda was initially established as really this as an association for women lawyers, and that was the beginning and the end of its purpose. But then in the 80s, the need for legal aid for women grew so great, and that we started exploring what can we do to make sure that we actually support women who are in need, and how do we make that transition to open up a legal aid clinic. And last week we hosted Mbogoh, who's our former Speaker of Parliament and one of the founding members of FIDAUg Uganda, and she said that she actually traveled to Nairobi and she met with the current who was the director of Kituo back in the 80s, and to be able to really benchmark what are they doing, how do you establish an organization like this, and how can you learn from what Kituo had already been done since 1973 and under really conditions with a lot of opposition and really being an actor that faced a lot of backlash at the time. And so it was so interesting for me to know just last week that Kituo has actually had such a leading role and input in the formative years of FIDAUg Uganda as a legal aid clinic. And it's quite special that we can continue this relationship of mutual learning and really exchanges of experience. And so Dr. Annette, I thank you very, very much. And that brings us to the end of our continuing legal education training for today. Goodbye, everyone.